Good afternoon, and thank you for joining us this afternoon. We are doing a session today on doing business in the Tweed. For those of you that don't know me, my name is Denise Galle, and I'm the Director of Planning and Regulation here at Tweed Shire Council. Before we kick off today, we just have a little bit of housekeeping to run through. Your cameras have been turned off and microphones have been muted. This session will be recorded and uploaded to Council's website for access at a later date. There are closed captions that are also available, and I have also turned on the chat function. So at the end of the presentation, I'll open the chat history and I'll be happy to answer any questions if time permits. So this is part of our October Business Month, and it's all about doing business in the Tweed, and that Tweed Shire Council is here to help you do business. First of all, I'd like to do an acknowledgement of country. Tweed Shire Council wishes to acknowledge the Nunjumwal and Minjabul speaking people of the Bundjalung country, in particular the Gudjambara, the Tulgaigan and the Murrung Mubar clans, as being traditional owners and custodians of the land and waters within Tweed Shire boundaries. Council also acknowledges and respects the Tweed Aboriginal community's right to speak for its country and to care for its traditional country in accordance with its laws, customs and traditions. So let's get started. The Tweed. I really want to thank you for joining me as we delve into both important and multifaceted topics of planning pathways for businesses in the Tweed. During this session, I'm going to try and help you to explore the intricate web of regulations, opportunities and challenges that businesses face when navigating the planning landscape in our beautiful Shire, and how these pathways are really instrumental in shaping the future of the Tweed. Tweed Shire is home to a diverse population and boasts a stunning natural environment, including pristine beaches, lush rainforest, and a thriving agricultural sector. The region is not only a haven for residents, but also a popular tourist destination. And due to the region's proximity to the Gold Coast and Brisbane, it's a very attractive destination for both residential and commercial developments. In the Tweed, we want to encourage sustainable business, but we operate in a very complex legal framework. So sometimes it may seem like we don't support business, but we do want to encourage people to work with council within this very complex legal framework to get a good outcome on the ground. So let's delve into it. The New South Wales Planning Framework. The Tweed Shire Council is the local government authority responsible for planning, development and infrastructure in the region. We play a pivotal role in determining the future of the area by balancing economic growth with environmental sustainability and community wellbeing. To achieve this, Council relies on a comprehensive planning framework, which directly impacts businesses operating within Tweed Shire. Given the complexity, realistically, most business owners will require assistance when navigating the planning requirements, and this would be from professional town planners. But Tweed Shire Council does offer free duty planning services. That's right, it's free. We have a duty officer available for phone calls in both the development assessment and building unit every morning. And we also have an online service where you can book for a 30-minute appointment, either face-to-face or virtual, to discuss the development application process free of charge. This service is to provide general advice and guidance for the planning process. Our website also has a list of private planners and other consultants who can assist with planning, certification and any expert advice that may be needed to help you do business better in the Tweed. To start off with, any inquiry, you have to figure out what your land use definitions are. There's several business development pathways available. Business owners are also required to meet a range of state and local government requirements to operate. It is the business owner's duty to ensure that your business operates within this regulatory framework. And to assist the business owners with this, our website has a vast amount of information available in relation to development and business. In the first instance, business owners will need to identify if their business is permissible in the chosen location. And to be able to determine the permissibility of business type, it's a land use definition that needs to be first identified under the dictionary of the Tweed LEP 2014. And the easiest way to access the dictionary is via our website under the Development and Business tab. So I'm just going to play this interactive slide for you. And the idea is not that you're going to do this at the same time that I'm doing this. This is quite a quick little video, but it will just walk you through it. So this video will show, if you go to the Development and Business tab on the website, then you click on Land Use Planning, and there's a link to our environmental controls, being our local environmental plan and our development control plan. And when you click on the relevant local environmental plan, and there's 3 in the Tweed, it will then take you to the New South Wales legislation page. And I just noticed that there's been a problem with that video playing, where it doesn't actually take you through to that New South Wales legislation page. But you can watch this back later and we'll fix that in the system. When you go to that New South Wales legislation page, the local environmental plan is a legal document, and at the very bottom of that document, when you look at the contents page, there's a dictionary tab. You go to the back of that dictionary and it's alphabetical, but you can also use the search engine on that to search the dictionary and find the relevant term that might apply to you. So if you're a food and business premises or a cafe or a restaurant, you can do a word search for those types of uses and find out the lawful definition of the business that you're trying to operate. Once the zoning has been determined, the business owner will need to refer back to the Tweed Local Environmental Plan legislation and the applicable land use table. And the land use table sets out the permissible and prohibited land uses. When reading the land use table, there are parent and child definitions. Once again, the current LEP is available on our website. Again, head to the contents page of the LEP and scroll down to the land use table, find the applicable zone. Not only does the applicable zone give you objectives, but it will set out the permissible uses and the prohibited uses in that zone. You'll be then able to determine if your proposed land use is in that permitted zone or not. And that video there is just showing that there's a prohibited list of land uses, but also permissible higher up. When you get into the crux of this, a food and drink premises is a type of retail premises, with a retail premises also being a child definition of a commercial premises. There are times when the land use table will prohibit the parent definition, but can permit a child definition. If a proposed business owner was wanting to open a takeaway cafe, this could be defined as a takeaway food and drink premises. This definition is also a type of food and drink premises, which is a type of retail premises. I like to think of them as umbrella definitions. You might have an overarching definition that defines it as a commercial premises, but that can be business, office, or retail. And then a food and drink premises will come under that as a type of retail. And then further below that is your takeaway food and drink premises. So with that example, if you're wanting to open a takeaway, this could be defined as a takeaway, and this definition is a type of food and drink, which is a type of retail. If the property that they were looking at opening the business in which it was situated, it was in the E4 zone, which is general industrial, even though commercial premises are prohibited, you'll see in the E4 zone that the child definition of a takeaway food and drink premises is actually permitted with consent. And remember what I said at the beginning, that the New South Wales planning system is quite complicated and you will likely need help from a professional town planner. And this slide is a perfect example of why you might need assistance. Because whilst you can be one definition, like a commercial premises, which might be prohibited, you may well in fact might be a takeaway food and drink premises, which is permissible. So if at the very beginning you're thinking you're prohibited, you might well in actual fact be permissible. Confusing? I know it's not a Tweed Shire Council system. It is a New South Wales planning legislation system that we all have to operate within. And that's why it's a collaboration effort between council and you as the business owner, and hopefully you with your professional town planners to help us get you the right outcome for the ground. Once you've done everything that we've just talked about, the next stage is if it's permissible in the zone that you're wanting to do it, you then have to have regard for if there's any current development consents or approvals in place that will enable your business to operate without any further development applications being required. If the business does not have a copy of the current development approvals or the history of the site, you can ask council for this information. And there's various ways that you can do this. You can apply for a development consent search. This is via our website through the conveyancing applications. Now, this is a paid search. It costs $204 to get a copy of a development consent, and we endeavour to have this search completed within 10 to 14 days. Or you can obtain a copy via the Access Request for Information, which is an informal access request, again through our website, which is something called GIPA. It's the Government Information and Access Request process. We do advise that sometimes there can be a fee for this, particularly if we have to reach through our archives to get you the information. Council's Corporate Governance Unit runs this process, and at the moment it is taking them about 30 days to obtain that information. The last option, and it's only really available for approvals and applications that have been approved in recent years, is that you can actually search back through what's called Council's DA Tracker. And this DA Tracker is available on our website. Once any existing approvals have been located, whether it be through our DA Tracker, through the informal access request, or through the conveyancing search request, you then maintain whether that site that you're interested in first has a lawfully commenced business and whether that approval is current. Did they operate it in accordance with the conditions of consent? Did they legally start that business in accordance with that consent? Is that consent still alive? If there is no development consent available and the proposed type of business is permitted with consent, then the business owner would then need to determine, well, what is my approval pathway? If I can't rely on an old consent, what's the rules today about what I can do? So there's multiple business development pathways. Exempt and complying development pathways the first, and this is a streamlined approach for smaller scale developments that may meet specific criteria, allowing for a faster approval time. Exempt developments generally have minimal impact and meet specific criteria as set out in State Environmental Planning Policy, Exempt and Complying Development Code 2008. This state planning policy is generally referred to as the Code SEP. With complying development, so if it doesn't quite meet those exempt provisions, the next process is, well, does it meet a tick box scenario of situations known as complying development certificates, or a CDC? If your proposal meets all the applicable standards under the code set for a CDC, you can potentially lodge a CDC application with either council or a privately accredited certifier. And there's a list of building certifiers and consultants on council's Get Advice website page. If you are lodging your complying development certificate with council, then there are some requirements that need to be met. For more information, please just go to our website on our exempt and complying webpage under the complying development section. Next, if you are not exempt development or complying development, for whatever reason you might fall out of those provisions, you may need to lodge a development application. Development applications all need to be lodged via the New South Wales Planning Portal. You'll need to set up a username and an account to access this service. But the New South Wales Department of Planning website has all the information to walk you through that process. Before you go lodging a development application, you need to be aware that you'll actually need all landowners' consent to lodge a development application. So if you live in a body corporate and you're wanting to do a patio over a common property driveway, you're going to need the body corporate's approval to do so. And before you can lodge on the New South Wales Planning Portal, you should have a fully prepared development application with landowners' consent and plans that talk to what you're wanting to do. And as I've said earlier, we do recommend that you engage the services of a planning consultant to assist you with the preparation of that application. Some of the things that you might like to consider in a development application, or you might be required to consider, is car parking, for example. Does your proposal comply with the car parking requirements? We need to regulate car parking requirements for any new development application, and failure to provide adequate provisions for car parking can actually deter customers from coming to your business, and it can be a safety issue. Therefore, any DA needs to comply with our car parking provision. Tweed DCP Section A2 or Section B2 in the Tweed City Centre area mandates the different types of car parking that is required for different types of businesses. Again, if you don't feel comfortable looking up these documents and understanding these provisions, a local town planner can help you navigate this space. You might also have to consider signage. Some business identification signage does not require development consent if the sign complies with those exempt provisions that I was talking about earlier. Replacement of a previously approved sign might not need consent. However, a brand new sign with a larger size or illumination or a different shape will certainly require development approval. And again, you can contact council or look up our development control plan for advice on this matter. Contributions might be applicable. And if you're new to business, you might not understand what contributions are. Contribution payments are applicable when the new use of a site is likely to create a greater demand on water infrastructure, sewer infrastructure, the road network, or contribute to council's administration costs. These charges are determined during the development application or a CDC process. Council's duty officer can help you navigate what those contributions are likely to be. If the development is considered an intensification where you might be going from, say, a retail shop to a food and drink premises, then contributions are likely to apply. You can ask for a quote based on your floor area and what your expected change is. However, that quote will cost you $216. We generally try to respond to all inquiries within 14 to 21 days along those lines. Some of the other things you might like to consider in doing a development application is heritage. Are you located in a heritage conservation area? We have a development control plan, DCP 18 heritage, and we also have a lot of information on our website. Places like Murwillumbah are also known as a heritage conservation area. And for more information regarding works within either or on a heritage site or within a conservation area, please just visit our website or ring up and speak to our duty planner. Footpath dining. Footpath dining applies for food and drink premises only. They need both a DA and often need what's called a Section 68 approval for functioning on council's footpath. Charges apply for the area used, and approvals are assessed in accordance with council's footpath trading policy. Council's environmental health officers can help you navigate this space and alert you to all of the requirements when dealing with food handling. Food handling areas in newly established food businesses need to have an approved fit-out plan, and they're inspected by council to ensure compliance with the Food Act and the Food Standards Code. Again, our environmental health team can help you with more information. Later this week, as part of the Tweed Business Month, we do actually have an environmental health officer who'll be walking through the food fit out provisions, doing a similar talk to what I'm doing today. So if that's something that interests you, I would encourage you to tune into that as well. Trade waste is another thing that might come up when businesses are lodging a development application. Some food businesses are required to get approval to discharge liquid trade waste into council's sewage system, and that might require the need for the installation of a grease trap to be installed. But again, between our environmental health officer and our water unit, there's always somebody here at council that you can ask for advice. One other thing that's not council related that comes up quite a bit is the Office of Liquor, Gaming and Racing, or OLGR. Where if you're a food and drink business and you're wanting to have a liquor licence, you need to have a liquor licence in place to serve liquor. Applications can be completed online through OLGR. They often refer these applications to council to ensure that the correct development approvals are in place. Food Authority retail food businesses are required to have a trained food safety supervisor in their businesses. We'd encourage you to refer to the New South Wales Food Authority website for more information regarding food safety supervisor requirements. So that ends the little bit of chat on lodging a DA. It's a very complicated system, and I'm happy to answer questions at the end of this via the chat, but I'm about to go on now and talk to you about some agritourism changes in the area lately. Agritourism, the recent changes, what is it? It involves inviting visitors to experience your existing agricultural operations firsthand. This can include farm experiences, farm tours, cellar doors, cafes, retreats, roadside stalls, fruit picking, hosting small weddings, and emphasis on small, and other activities. The purposes of these changes, as per the New South Wales Planning website, is to help landowners add value to their existing agricultural operations and encourage the next generation to actually farm the land. They also want to help make farms more resilient to the economic impacts of natural disasters and other unexpected events. And they want to support sustainable tourism, giving people more reason to visit the regional and rural New South Wales. One of the common questions that we're getting in relation to agritourism is who can actually do this? And the first question that must be addressed is the land requirements. The land must be a commercial farm on which agriculture is undertaken. This must be on land that's either categorised as farmland by council or a primary production business under the Commonwealth tax legislation, or part of a primary production business. The land cannot be a hobby farm or a recreational farm. The primary production has to remain the primary use of the land. On the New South Wales website, there is an extensive information available on a how-to guide for setting up an agritourism business. Again, you'll be able to access that link when this PowerPoint presentation gets uploaded to our website. So what are the definitions under the Tweed LEP 2014 in regards to agritourism? There have been some recent changes to the New South Wales legislation which have included agritourism, which include farm experiences and farm gate premises as being permitted with consent in the RU1 primary production and RU2 rural landscape zones under Tweed LEP 2014. There have also been recent changes to the SEP codes, which allows for farm experience premises, farm gate premises and farm stay accommodation under the exempt provision. But remember, for all of these, it still needs to be on a commercial farm, which is the primary use of the land. It cannot be a hobby farm. So what are the different pathways? If we think back to what we just talked about with the DA, agritourism has the same pathways. So to start off with, what can you do as exempt development for agritourism? So up the top there, we've got no approval needed for exempt development. This is for low impact development that does not need planning or building approval. So a change to the use of a rural workers dwelling to a farm stay accommodation is an example of something that might meet the exempt provision. Constructing glamping platforms, picking your own produce or farm tours are examples of what could be exempt development. And this is good for small-scale agritourism ventures. It certainly still must comply with specified development standards, and it allows agritourism uses and some minor building works. But there are some exclusions that apply. So if you're not familiar with this process, again, I'd encourage you to seek help from a council's duty officer or your own town planner. The next step is fast-track complying development, the CDC route that we talked about earlier. This could be a combined planning and construction approval for a straightforward development where building work is involved. And again, remember, it could be determined by council or a registered certifier. An example of this would be a construction of a new building for alterations and additions to an existing building or farm stay accommodation or a farm experience. Some things to note with this is that you still need to comply with specified development standards, and you must meet all of them, and some certain land exclusions are applicable. In addition, neighbour notification might be required for this provision. If you're still wanting to do something that doesn't meet the exempt development pathway or the complying development pathway, it's the development application pathway that applies. And from a development application point of view, this would involve the construction of new buildings, change of use or alteration of additions to existing buildings. And some councils can provide a pre-DA service, it says. So I've already advised that we have both free duty service, a free booked-in 30-minute consultation session, and in addition to that, we have what's called our Development Assessment Panel, which provides pre-lodgement advice for a fee. So some of these more complicated agritourism DAs might fall into that process as well. The reason I wanted to talk about agritourism today is that it is a new sort of set of planning definitions. And I think with the introduction of the rail trail in the Tweed Shire, this is something that more landowners will be investigating. But please don't forget that you still need to have a primary farm in the first instance, and it cannot occur on a hobby farm. I hope you've found that information useful in terms of just some tips and tricks on how to navigate our website, looking at the hierarchy of definitions, understanding what agritourism is all about. I'm now just going to head into what I call the elephant in the room often, and which is development assessment times. Hopefully we're moving from this image up here, number 1, down to this image number 2, where we've had a historic problem where there was a perfect storm created that resulted in a DA backlog. And this was not just Tweed Shire Council, this was across the state and across the country and even across the world are having similar DA backlog problems. It was COVID, it was the federal and state government changes and incentives to build. During COVID, nobody could go overseas, we were locked down. So instead of spending money on holidays, people decided to spend money investing in their properties. And that was building pools and patios and pergolas and developing secondary dwellings, which is all wonderful things. But add that into a global supply chain problem, global staff shortages, lots of Land and Environment Court appeals at the time. It just resulted in a huge backlog of work. So in November 2022, Council had 540 outstanding development applications and modifications. That's probably that point where we're all tearing our hair out. Local businesses are tearing their hair out, staff are tearing their hair out. There's just too much work and not enough people to get that work done in a timely manner. And it's not something that we were proud of. But through DA process improvements, a couple of DA team blitzes, some teamwork and some collaboration with the industry, we've managed to get that down to 395 outstanding applications today. There's still work to be done, but we always want to work with you. And I think together, if we can encourage applicants to lodge better applications and consultants to lodge better applications and more robust applications, then we can collaborate going forward to make sure we get on ground better outcomes. So one of my mottos is a problem is only a problem until you turn it into an opportunity. And that's certainly what we're trying to do in that development application space. We're trying to turn those problems into opportunities, and we're trying to do business better. But it takes time, and that's where we really would like to encourage all of you to work with us and help us be part of the solution. So that concludes my PowerPoint that I have for you today. I thank you for listening and for tuning in, and for people that will tune in later, I thank you as well. I'm just going to shut down part of my system now and open the chat functionality and see if there are any questions there that people might have. So just bear with me while I do that. And I can see that it's a pretty small group here today, and so far there hasn't been any questions. So I'm more than happy to open the floor to other questions as well. If you didn't want to type it in, if you wanted me to try and unlock you so that you can speak, I can do that now. So just bear with me. Joanne, I can see you've got your hand up, but I just can't unmute you at the moment. Are you able to type your question there, Joanne? Oh, actually, I think I've suddenly got somebody there that has unlocked you.
Yeah, I think I've unlocked myself. Can you hear me okay?
I can.
Good. Hang on a sec. I've just got this old Logitech system. Hi, Kim. Hi, Cameron. Thanks, Annalise. Yeah, I was going to type it in. I just have a question about short-term accommodation in terms of agritourism. Is there a situation where these people who are signing up for Airbnb and VRBO and all these other short-term accommodation providers, do they also have to make DA applications and have consent applications in under the agritourism? Because you have specifically said that hobby farms can't do this.
Yeah, the hobby farm is definitely. Sorry, I'm just getting a bit of feedback here. Joe, you might have to mute yourself so I can't hear myself back through your audio. Thank you. Thank you. Okay, so there's a couple of things there. So short-term holiday letting definition has to occur in a lawfully approved dwelling to start off with. So we've got to be very careful in the New South Wales planning system not to mix land uses and definitions. So short-term holiday letting is short-term holiday letting in an approved dwelling. So you have to get the approved dwelling through your DA process first to be short-term holiday letting, which would encompass the Airbnb provisions. So, for example, if you had a dwelling on a rural property that you wanted to short-term holiday let, short-term holiday letting is permissible in a rural dwelling, provided it's an approved rural dwelling. The next step that you've just talked about with agritourism, and if we go back to some of the slides there in terms of what they can be, you might be let's get a term here, farm stay accommodation. So farm stay accommodation is not a dwelling. So you wouldn't be able to do short-term holiday letting in a farm stay accommodation. You would have to meet the defined term of what farm stay accommodation is. And farm stay accommodation is accommodation for the purposes of that working farm, and the farm has to first be a working farm to get that. So it's really important in planning to stay in your lane and not cross over those definitions, which I can understand is a little bit difficult. And that's going to be the problem for council as we go forward enforcing these different things, is that people are going to confuse them and go, but I didn't think I needed approval for short-term holiday letting, which you don't, but short-term holiday letting has to occur in a lawful dwelling to start off with. Has that answered your question enough, Jo?
I think so. So thanks for that.
As I think I started the presentation with, the New South Wales planning system is very, very complicated. So we don't have all the answers, but we're certainly happy to try and help you along the way. Okay, anyone else with any questions? Nope. Well, listen, thank you for taking time out of your busy day to listen to me talk about that. We're going to refine the recording and probably just top and tail it with some of the chat that was going on at the beginning. And then when we've got that ready for our website, we'll certainly pop that up on our website. And if you found it useful, please direct colleagues, friends, that they can have a look at it at another time. And also, I just encourage you to please use our website. We put a lot of time and effort into our website to try and help you and your businesses. And if you ever find anything on there that's not quite as helpful as you'd like, please be free to give us that feedback, and we will be happy to review it and make it more user-friendly as necessary. But on that, I just want to say thank you for your time. Appreciate you tuning in, and good luck with any business ventures going forward. Oh, I've just got Cameron typing something there before I hit leave. Oh, Joanne, thank you. Glad you found it helpful. Great. Oh, can I define the difference between farm stay and short-term letting? Yes, we can certainly do that. I'm just going to get, I've got trustee Joanne here just assisting me, and I'm just going to get her to get those terms up for me. Just bear with me. Okay, so it's in the housing set. Short term. So I'm just going to the housing set now. Definitions. Just bear with us. There's a few definitions here that we're going through to find that for you, Cameron. So you wanted the difference between the farm stay. Not sure that farm stays in that one, Jo. I think it's in the standard instruments set. So Tweed LEP 2014, the definition just down the bottom there. Right. Farm stay. Okay, sorry about that. Got that up now. Okay. Okay, so farm stay accommodation is a building or place, A, on a commercial farm, which is what we're talking about. B, it has to be ancillary to the farm. And C, it has to be used to provide temporary accommodation to paying guests of the farm, including in buildings or movable dwellings. So they're the three provisos. Short-term letting, I think that has a different meaning under the Residential Tenancies Act provisions. But if we're talking about short-term stay or holiday letting in a approved dwelling, like to be exempt, just bring that one up. Short-term rental accommodation is to support short-term rental accommodation as a home sharing activity or a contributor and contributor to local economics while in managing the social and environmental impacts from this use. And the idea is to provide for the safety of users of short-term rental accommodation who may be less familiar with the dwelling. So then you've got definitions that sit under that for what the host is and what is a hosted short-term rental accommodation, which is short-term rental accommodation provided where the host resides on the premises during the provision of the stay. And then you've got non-hosted short-term rental accommodation, means a short-term rental accommodation provided where the host does not reside on the premises. So if we go back to what short-term rental accommodation is, it means a dwelling used by the host to provide accommodation in the dwelling on a commercial basis for a temporary period of time. So going backwards then, the difference is that the farm stay one has to be on a commercial farm, has to be ancillary to a farm, and it must be used by the temporary accommodation. There's also further information on the housing set and also on the Department of Fair Trading website who regulate that short-term housing provisions. So hopefully that answers that. Got a question here coming through now from Melanie that the rural land strategy indicates that secondary dwellings are permissible on the RU2 land greater than 10 hectares, but in the LEP 24, secondary dwellings are not permissible. Can you advise? I can do that without looking that one up, Melanie. The rural land strategy is a strategy that considers what development might be capable of being done in the future. For that to actually be possible, it would actually need an LEP amendment. So at the moment, the LEP prevails and secondary dwellings are only permissible in the rural areas as attached dual occupancies. And until we revisit the rural land strategy, which we are doing, so the rural land strategy said that we would investigate secondary dwellings. We're investigating secondary dwellings through the growth management housing strategy. So our current growth management housing strategy stems from an action out of the rural land strategy, and they will inform what local environmental plan changes this council wants to consider going forward. So rural land strategy, it's a strategy document only. It's not law. The law is the local environmental plan where you can only do attached dual occupancies in the rural areas. So hopefully that one answers that for you, Melanie. All right. We've got Melanie typing again, and I'll give her a second. You can also unmute yourself, Melanie, there if you wanted to talk. Nope, the chat's just dropped off. So it looks like she's typing and then it drops off. Looks like it's all good. Do I know when it's going to get looked at? We're currently reviewing the growth management housing strategy as we speak. So we're going to have some information fact sheets come out before Christmas. And then in the new year, we have an options paper for the growth management housing strategy. And then that will inform what's going to happen with our local environmental plan. And that will look at what our housing provisions are going to look like over the next 20 years. So thank you so much, Melanie, for that question. And thank you for everyone's comments. Cameron's just sent through a thank you. Hopefully you can, if you're interested in those food and drink ones, tune in to one of our presentations next week from one of our environmental health officers, which will go through the requirements for food fit outs. Again, if you take any messages away from today, the New South Wales system is complex. Some business owners can think that that means that we don't want to do business with you. It couldn't be further from the truth. Tweed Shire Council really does want to do business with you, and we want to help you and we want to collaborate with you. But we are working in a very complicated framework. So we definitely need some AI to help, Cameron said in the chat. We need a chat GTP for how to do better. Again, thanks for your time, everybody. Thanks for your questions, and please reach out after this as well to our channels. If you want to email council, it is tsc@tweed.com.au. www.newsouthwales.gov.au. If you've got any questions for me, direct them to Denise Galle and I'll do what I can to help you. Thanks, everybody. Have a lovely afternoon.